I'm going to just order that you start your 30-day sentence, and then I'll give you parole for the balance of the year. So, Missy, can you have a deputy go ahead and take her in?
I'm not fucking doing it.
Hey. I'm here.
Right.
I'm not doing it.
All right, take her into custody, please.
Hey.
Of the unfairness of the laws that would fraudulently assume if I take a lawyer that I would be giving up my right to be one of the sovereign people and be fraudulently assumed to be a legal fiction defendant. Yes, I have refused that.
I'm not going to argue with you, Mr. Martin. I understand your sovereign citizen argument. It's not the first time I've seen it or heard it. You are under the jurisdiction of this court. This court has jurisdiction under the Michigan Constitution and the laws of the state of Michigan. You are charged with a 93-day misdemeanor, sir. You've been advised of all of your rights. Okay, you have a First Amendment right, certainly, but you are here for an arraignment, not to lecture me on sovereign citizen belief.
I want Mark arrested for illegally arresting me. I want him charged for assault and battery, for illegally arresting me, and kidnapping.
Rebecca Stewart there at the Greenland County Courthouse.
She is.
All right, let's take her up next.
Ms. Stewart, if you'll come up closer to the screen, please. We're on the record in 2023 TR 381, State of Kansas versus Rebecca Ann Stewart. Paul E. Dean for the state, Richard Paul for the defendant, who also appears in person. And Mr. Paul, what announcements do you have on her?
Judge, you set this. We pled her, and then you ordered her jail time. And she was supposed to be bringing her work schedule in today to schedule her time.
Has she done that?
Ma'am, I just started working. They told me that the days that I could get off is on Thursdays and Fridays. But I have to go to orientation tomorrow.
What do you mean you just started working?
Well, I ended up getting a different job, and I just started working there.
Well, when you were here March 29, 24, you needed some time to get your work schedule figured out before you started your sentence. You were supposed to serve 30 days. So we set it over for today, and you had just left a job at Sonic the week previously. And you were interviewing at a different Sonic. So did you start the job at Sonic?
I was working at Sonic, but it didn't work out. I had an interview at a nursing home, but with my background, I couldn't do that. But I'm starting work at McDonald's.
I gave you a number to call immediately after court for probation. Did you do that?
Yes.
I'm sorry?
Yes, I did call.
Did you tell probation that you didn't start your job?
I did start my job. I did. I was working.
But then you left that job.
We had a disagreement, and I went and I was looking for another job right away, and I found one.
Did you tell probation all of that?
I wasn't for sure I was supposed to.
All right. Well, let's just start your sentence at this time.
I can't. Ma'am, can I please do like weekends, please? Because I don't have a babysitter. Ma'am, I don't have a babysitter, and I'll lose my job.
How long have you had this job?
I'm just starting, and that's how I'm going to.
Just starting when?
Tomorrow. I go to orientation tomorrow.
That's what you told me last time you were here, and you didn't keep that job. And you have a horrific record. I think we went over all of that the last time. With your adult history beginning in 2016 and remaining heavy right up to this case, other than I think you may have had a stint of time to serve in there, but you've had everything, including drugs, burglary, theft, traffic.
Yeah, but I'm changing my life around. I'm just asking if I can do weekends.
Do you still have charges pending in Allen County for felony drugs and 5
I've
other?
taken trial. I've been clean. I've been sober. I haven't.
Hold on, just answer my question, please. Do you still have that 2023 CR 117 for felony drugs and 5 other charges, including driving while suspended third or more? Do you still have that pending?
My court dates are far apart.
Well, your last court date when you were here was March 25th. Did you go to that court date?
Yes.
And they set it over again?
Yes.
And do you still have Allen County 2023 CR 300080 for domestic violence?
I go to court on that on this, I think, 17th.
And do you still have Allen County 2023 CR 300018 for possession of stolen property?
All of Allen County's court dates are on the same day.
What date is it?
I think the 17th.
How about Allen County 2023 CR 81 for stolen property?
It's all on the 17th.
And Allen County 24 CR 9 for criminal damage?
The 17th. I've been making all my court dates and I've been doing what I need to do. I'm just asking that if I could do weekends or Thursdays and Fridays, that way I don't lose my job and I have my.
What's this? Well, I'm not sure. You have some other counties with felony drugs, driving while suspended, improper passing a school bus, something that goes back to April 21st, 23. What county is that in?
The only county that I knew of was Neosho and Allen.
Okay, Neosho would probably be the NO. Okay, and that's still pending?
Yeah, they've set my court date so far apart on that.
The driving while suspended third or subsequent and improper passing of a school bus, that's pending?
Yeah.
And let's see, you got out of prison after 4 years in 2022, and all of that plus our case have been incurred since you were let out of prison in 22, right?
Yeah.
And I sentenced you to 6 months in jail to serve 30 days and then report to probation for the balance of the year.
Ma'am, I swear I won't drive no more and I will get my life turned around if I can just do Thursdays and Fridays.
Well, you told me you haven't kept your word to me, because rather than put you in jail the last time, you said you'd left your job at Sonic a week ago and you had an interview the next day. And I took you told me that you had your 2 children living with you. Who did they live with while you were in prison?
My mom, and she has lung cancer.
Yeah, that's what you told me last time. And you said she's not able to watch them, right? Well, I've given you since March 29th to get this all worked out, and you've changed jobs. You apparently haven't gotten a babysitter because you say you need weekends.
I have a babysitter on Thursdays and Fridays.
I'm going to just order that you start your 30-day sentence, and then I'll give you parole for the balance of the year. So, Missy, can you have a deputy go ahead and take her in?
I'm not fucking doing it.
Hey, I'm
Yeah.
here.
All right,
I'm
thank
not
you.
doing it.
All right, take her into custody, please.
Hey.
Now, when she's released, she can go to parole. But she took off before I could tell her she needs to report directly to probation for supervision. Probation / is that Carrie down there? Great. Okay.
That was Carrie, Judge.
Carrie, she used to do 30 days, and then I want her to sign up, but she should have signed up with you by now. Did she do that?
She did call, Your Honor, but Jessica is the one who got the phone call, and I haven't heard from her since. That's why I came down here to have her fill out paperwork for me. So I was just waiting here to see what would happen in court.
Okay.
Paperwork and let her know.
All right. So, yeah, And if she doesn't want to cooperate, then you'll do whatever it is you need to do. But, yeah, I'm going to have her serve 30 days of her 6-month sentence, and then she can report for the balance of the year if she will do that. Thank you.
Thank you.
And for the record, that was Carrie Seeley with Court Services. Okay.
Mr. Panther.
I'm looking forward to it. All right, this is 241388, the state of Michigan versus Eric Joseph Martin. Sir, can you tell me your name?
Oh, not the Roman Sesticate Trust, if that's what you're wondering.
Okay. Are you going to tell me your name or not, Mr. Martin?
Well, I just want to make it clear, I'm not the legal fiction corporate entity defendant.
Okay. All right.
If I give
Sir, if you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please let the court know immediately. You are here today on count 1, domestic violence. There's an allegation that on June 8th of 2024 in the city of Taylor at Clifford, that you did make an assault or an assault and battery upon Crystal Nicole Martin, a resident or former resident of your household, contrary to MCL 750.81 parent 2. This is a misdemeanor punishable by up to 93 days in jail and or $500. A consecutive sentence may be imposed under MCL 750506A if the assault was committed in a place of confinement. Those are the charges against you. You've been brought to court on a misdemeanor charge, and you have the following basic rights: to plead guilty, not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered, and you may plead no contest with the permission of the court. You have the right to a trial by a jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, meaning you cannot afford to pay for an attorney. If the offense requires a minimum jail sentence, this charge does not have a minimum jail sentence. The court determines that it might sentence you to jail, and the appointing authority, which is the court, would decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of the appointed attorney, and you may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must then determine your ability to pay. Mr. Fanto, a court-appointed defense attorney, is present in the courtroom. It's my understanding he attempted to meet with you, and he was advised that you did not want to speak with him. Is that correct?
Because of the unfairness of the laws that would fraudulently assume if I take a lawyer that I would be giving up my right to be one of the sovereign people and be fraudulently assumed to be a legal fiction defendant, yes, I have refused that a lawyer
Mr.
fraudulently represents me.
If you have a trial, you have the following rights: to call witnesses to speak for you at trial, and you could get an order signed by the court to require those witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official could not comment on your refusal to testify. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you will give up the rights that I just listed to you. You also have the right to be released on bond. If you are now on probation or parole and you enter a plea of guilty, or a finding of guilt is made by a judge or a jury, it may result in a violation of your probation or parole. The court can sentence you to jail and fines plus cost, and the court must tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, and both, which I've already done. Fines, costs, and other financial obligations imposed by the court must be paid at the time of assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, you can contact the court immediately and request a payment alternative. So those are your constitutional rights going forward, Mr. Martin.
I want to make it clear I have been legally arrested here by barred away, okay, because he just went by her lies saying I kicked her. As soon as he walked through my door, I'm the one that called 911 on Crystal Martin, okay?
All right,
And,
sir, you have a constitutional right to remain silent, and anything you say with respect to this case could potentially be used against you in a court of law. So I would advise you at this time to remain silent with respect to the actual facts or allegations listed in the complaint and misdemeanor complaint, which I've read to you. Sir, are you gainfully employed?
I wish to finish before I answer your questions. I will answer your questions. I want to finish exercising my First Amendment right, freedom of speech, and continue what I was saying.
Okay, sir, you are to appear in court as directed. I'm not going to argue with you, Mr. Martin. I understand your sovereign citizen argument. It's not the first time I've seen it or heard it. You are under the jurisdiction of this court. This court has jurisdiction under the
Sovereign citizen arguments may feel convincing to the person making them because they give the impression of controlling the legal process. However, courts operate based on jurisdiction, established laws, and legal precedent, not personal beliefs. When someone repeatedly claims the court has no authority, it often makes them appear uncooperative. That perception can influence important decisions such as bond, custody, and release.
Michigan Constitution and the laws of the state of Michigan. You are charged with a 93-day misdemeanor, sir. You've been advised of all of your rights. Okay, you have a First Amendment right, certainly, but you are here for an arraignment, not to lecture me on sovereign citizen beliefs, okay? I'm trying to get you through this and make sure you understand the process. You are to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with the complainant, Crystal Martin, in this case. Do you understand me?
No, I do not understand in that I do not stand under the charges, the false fraudulent charges, but I do comprehend. But as I was saying, I was illegally arrested in violation of my due process rights. There's not sufficient evidence for my arrest that I did any domestic violence. Bardaway just arrested me anyway. There's no video of me assaulting her. She did not see it. She just told a lie. I actually filed a PPO on her.
Sir, do you understand that they have no contact with Crystal Martin?
And then you need to tell her, do not come to my house. She keeps coming to my house so she can set me up with these lies because my sister keeps letting her over. I have no I want to contact her, but she needs to stop coming over to my house. You know,
Miss Maudlin,
let me finish talking. I have the First Amendment right to talk. I have the
Mr. Martin, it's clear to me at this point that you have no respect for the court. I believe that you're a danger. I can't get any information from you as to whether or not you have another place to reside, whether or not you understand the court's no contact provision. I need to know that you understand what I am telling you, because I am attempting to set a bond on your case. And if you want a bond on your case, you've waived your right to an attorney. And I'm trying to figure out, do you have another place to stay? Do you understand what no contact means? And if you're not going to express to me that you have an understanding of what I'm saying, and if we can't get on the same page about that, then I'm inclined to not give you a bond. Do you understand me? Officer, can you unmute the iPad? Do you understand me, Mr. Martin?
I comprehend you, yes.
Okay, do you understand that I said you were to have no contact with Crystal Martin?
Yes, but she needs to stop coming over to my house. I'm not trying to contact her. She's coming over to my house so she can make false allegations like this, set me up so she can have the whole house to herself, her and my sister. this is what the whole agenda is of her with my sister Lisa Martin. Tried this before, even though I proved to the court before the video of my sister Lisa Martin trying to set me up with lies and try swinging at me, assaulting me. I have this on video, saying with Crystal Martin here. I have her on video swinging at me and dealing with the prior case she tried to bring in. Okay.
So,
I have evidence that she can address it towards me.
Mr. Martin, does Crystal Martin live at the home on Clifford Street?
Yes, she comes over like for a day or two, and my sister lets her come over, and she stays there for a day or two. Yes, and then here and there.
Okay, so your sister owns the home.
No, she doesn't own the home thing. So my understanding is the bank really owns it. It's always been like my parents' house. But I don't even think really my parents own it because they didn't finish paying off the mortgage or whatever. So I think technically it's the bank's house, but me and my brother and sister have been staying there for a long time. Me there for like 32 years. My parents have passed away now, so now it's like a fight with them two. They're trying to take over the whole house by coming with false allegations, by telling cops, oh, he assaulted me all the time. There's no evidence. It's not true. It's a lie. There's insufficient evidence in violation of my due process rights. But Bartaway arrested me anyways, and this is just what she wants. So they can have the whole house to themselves. I even filed a case with Crystal Martin.
All right, so you're not to have contact with Crystal Martin. You're not to return to 9 Clipper in the city of Detroit, or in the city of Taylor, I'm sorry. You're allowed
Objection, it violates my due process. You cannot deny me my right to live at my house because of an unsupported allegation by her, which is a lie at that. Like I said, the cop had no sufficient evidence. She just told a lie, and the guy didn't even, Bartaway that is, the police officer, just came to me and arrested me right off the bat. That violates my due process rights with sufficient evidence.
Sir, you're allowed one visit to the premises to obtain personal belongings. You must be accompanied by a police officer.
And I want Bartaway. Well, hold on, I'm gonna let you finish. I'm just gonna finish what I got to say so you don't cut me off. And I want Bartaway arrested for his illegal arrest. I want Bartaway arrested for illegally arresting me. I want him charged for assault and battery, for illegally arresting me, and kidnapping.
Okay.
Because it was without my consent.
Mr. Martin, if you are not allowed at the 9074 Clifford Street address, where will you be staying?
I am allowed. I don't have nowhere else to live. That's my house. I'm allowed there. You ordered that to illegal. That violates my due process.
All right. He has a $2,000 cash bond with a GPS tether.
Yes, objection. That violates my right to a personal bond.
He's not to appear at 9.
Without guilty.
He cannot come to 9 or be in contact with Crystal Martin. I've entered a not guilty plea on his behalf. And that's $2,000 cash with the GPS tether. All right, thank you.
These are two very different defendants, but they faced the same reality inside the courtroom. In the first case, the defendant tried to negotiate when her jail sentence would begin. Her approach was straightforward: explain her job, describe her childcare situation, and request to serve time on weekends. But the judge wasn't focused on today's explanation. The decision was shaped by her past, prior convictions, new pending charges, and earlier promises that didn't hold up when the court previously granted her extra time. In a courtroom, credibility isn't created in a single moment. It's built or lost over years. Once a judge believes a defendant's word no longer carries weight, the available options quickly begin to shrink. The second case reveals a completely different mistake. This defendant didn't try to work within the system at all. Instead, he leaned on familiar sovereign citizen language, rejecting the legal fiction, alleging constitutional violations, and refusing to recognize the court's authority. But arraignments aren't the place where courts debate sovereignty theories. Judges focus on risk, compliance, and public safety. And when the judge couldn't get clear cooperation or confirmation that the defendant understood the conditions, the outcome shifted from potential release to strict control: a $2,000 cash bond, a GPS tether, a no-contact order, and removal from the home he claimed he had the right to occupy. Neither defendant intended to make their situation worse. But in courtrooms, small choices, ignoring advice, challenging jurisdiction, or damaging credibility quietly add up. And once they do, the judge's options become limited. So do yours.